Uniform Trust Code, also known as UTC. This is a federal statute from Congress, and it was put together to guide the states on how to deal with trust. Now, sections 106 and 107, they deal with common law trust, again, what the IRS says don't exist, okay? But let's sum that up with the Uniform Trust Code, what they actually say. So, basically, the Uniform Trust Code, it does not try to incorporate detailed rules, okay, for every conceivable kind of trust, because there's so many out there. It does not contain statutory rules that are already governing trust in many jurisdictions and that are working just fine. It does not displace any of the actual trust or acts that are out there already. It's just a basic set of default rules that are fairly consistent and they clearly govern voluntary trust. And that last line is very key. That's why it's highlighted in the plan, okay? It's a default statute for the most part because the terms of a trust instrument will always govern, even if it's inconsistent with what the statutory rule says. So at the end of the day, even though there's a guide for the Uniform Trust Code for the states to use, the trust contract, whatever is in there, supersedes anything that's in the UTC. Very, very key. Very, very key. So that's how powerful the trust contract is. What we're going to do right now is wrap up with the most cited court case that has everything to do with all that we've been talking about here, and that is Hale versus Hinkle. And Hale versus Hinkle, this is all about your right to privately contract. This is the most cited case in American history, ladies and gentlemen. Okay? And the Supreme Court, that's the highest court. That's what the president has to go to. They bypass all these other courts. They go straight to the Supreme Court, the president of the United States. The great thing is we have the option to operate in the same space. The way we determine how we operate is to go straight to the Supreme Court, is we determine it up front. So we're going to operate in the Supreme Court space, common law, English common law, or in some other jurisdiction. Okay. Now, this case has been cited over 1,600 times since 1906. I want you to understand what that really means. Because you, like me, that didn't really make a whole lot of significance to me. Okay. But Supreme Court, if you see the more times that the case is held up as law, the more it becomes cast and granted. And has anything ever overturned Hale versus Hinkle? Never. There's not been one issue, one case that has ever overruled Hale versus Hinkle. However, it's been cited many, many times. So it is what we call the law of the land. And let's see what this actually states. Basically, in a nutshell, I'm not going to read all this thing for the sake of time. But you go look it up on your own. Hale versus Hinkle. You can go Google it, whatever the case may be. It's talked about us as an individual. We may stand upon our own constitutional rights as a citizen. We're entitled to carry on our private business in our own way. We have the power to contract is unlimited. We can contract as many times as we want, however much we want. We owe no duty to the state or to the neighbors, our neighbors, to divulge our business and what's in our contract. We don't have to open our doors to any investigation at all. Basically, as long as, and I'm skipping over to the third column, it says, in the highlight, as long as we owe nothing, as long as we understand we owe nothing to the public, so long as we do not trespass upon the rights of others. Very, very key. So you see, we owe nothing to the state, neighbors, or the public, as long as it doesn't infringe on their rights. So Nelson Rockefeller, the Rockefeller family, Mitt Romney, Donald Trump, and yours truly, honestly, to name a few, we exercise our right to private contract. We know the battle has already been won. We are very clear on that. As I said earlier, it's been won. I spent time going through all this, including all these court cases at IRS.gov, to show you that it's not your fight, ladies and gentlemen. It's your choice to get on the winning side. The side where the battle game has already been won. The side that they don't purposely teach us. Who else knows the battle has already been won? Let's take a look. Here's a case study with Mr. MacArthur Seabury. And he actually sent this in. I was so grateful just for him sharing this. The products and services offered by Divine Order are nothing less than remarkable. I did not know exactly what I was looking for, but I knew there was something that I was not being told. The information has been gathered, compiled, and shared, and has provided me with the right level of detail needed to simplify the complexity of the laws and understand the underlying concepts and principles that are contained in the supreme law of our land, that Constitution. To that note, I was looking for professionalism, extensive knowledge, and ongoing support, enabling me to establish financial freedom, realize liberty, and continue my pursuit of happiness. Kudos to Ms. Monica Andrews for her dedication to excellence and is paving the way for my family to receive a legacy that they would be very proud of. We're very proud of Mr. MacArthur Seabury as well. And kudos to you for taking advantage of this bulletproof system. We're so proud of you, man. So this bulletproof system, ladies and gentlemen, that business trust we went through, that's where the earning happens, where the business is growing in earnings. You start at $500,000, okay, whatever you're earning, but it's dispersed. You do not keep more than 1 month, maybe 2 months, depending on the time, of operating expenses in that account at any given time, because that's the one that deals with the public, the business trust. But we disperse everything to its beneficiary, the family trust. That's where the living and the donating happen in your family trust. Very, very key. It's an entity that does not deal with the public, so you leave your assets there, protected. And then we donate to the private family foundation, 501c3, a non-operating foundation, where you do your giving and you build your legacy there, ladies and gentlemen, as you saw. This is all legal. This is all lawful. To do what? Position, which is number one, the first tenet of wealth, to protect you, which is the second tenet of wealth, and to pass on all your money to your legacy, free and clear, which is the fourth tenet. So here's the key, though. The paperwork must be specific under the common law. It's very, very important for you to understand that. So you want to make sure that you are sitting down with someone that knows and understands this concept. Because again, it's something just as small as capitalizing the states or using the abbreviations or any lowercase. Something as simple as that can throw you back in the wrong jurisdiction, ladies and gentlemen. So you want to make sure you connect with somebody that understands the common law. Okay? Now, I wanted to make sure I cover this whole thing with asset protection. Okay? Because we talked about the business piece necessary and so forth, and that's great. Like Rockefeller knew. He knew that ownership is a liability. Now, because of that, when you own something, that means it can be taxed or it can be taken from you. That's why I state very, very, very sincerely is that everyone needs a family trust. Every single person needs a family trust. Every single family needs a family trust. You do not want your bank account, your homes, your annuities, your pensions, your boats, helicopters, planes, your insurance policies in your name. Why? Because as Nelson Rockefeller knew, it could be taxed or taken away from you. You want your assets in the name of a family trust that you control, ladies and gentlemen, that you control. what I got to say to you is, timing is everything when it comes to protecting your assets. There's something called the 5-year look back. You ever heard of the 5-year look back? 5-year look back. Let's look and see what that is real quick. The 5-year look back basically is when you apply for Medicaid, whether you have a little or a lot, they're going to use your assets first before giving you the assistance that you worked so hard for and paid into. This means they're going to make you sell your home, empty your bank account out, your annuities, insurance policies, etc. It's called spin down. You can't give it away. If they found that you gave or transferred any assets within 5 years of your application, guess what's going to happen? You'll be penalized. Any transfer or gift outside of 5 years is subject to no penalty at all, though. That's the key. That's why I say timing is everything. I want you to know that Medicaid is not only for seniors. There are times when young adults have to utilize those services, so they have to pay for care out of pocket. Again, diminishing their wealth with their assets. They'll make you sell your house, or they'll make you sell everything else down to no more than $2,000. Yes. The look back, you cannot give it away. You can't spend on extravagant anything. It has to pay the nursing home. So when they look back and see that. Yes, I want you to know, nursing homes, they're anywhere from $8,000 to $10,000 a month, depending on where you are, even more, just depending on where you live, where you reside. And they make you pay all that until all your assets are gone. And joint bank accounts don't even matter. They look at what you have and they have you spend it. They leave you $30 a month, ladies and gentlemen, for incidentals. That's to get your hair done, if you want a piece of chocolate or whatever the case may be. You want to buy a gift for a family member, get your nails done, whatever the case may be. They'll actually make you sell it. Even if you put it in your daughter's name or your son's name or whatever the case, you'll be penalized. And as of 2020, every state but California has the Medicaid look back period of 60 months, which is the 5-year period. Even in DC, it used to be 1 year a couple years ago, DC. California has 30 months, that's 2.5 years, okay? So timing is everything. I hope you can see why I say everyone needs a family trust. Greetings and welcome to putting money back in your pocket, creating money momentum. You're going to learn how to leave a bulletproof inheritance and a legacy without worrying about it. Get ready, because I have some great information to share with you. Did you know there were 2 sets of financial information? Yes, that's right, private and public. You see, I was born on the public side. I was taught to go to school, get good grades, go to college, get a great job, get married, have children, retire, and grow old, living off a percentage of what I was making at the time, and to be satisfied. Understand, ladies and gentlemen, there's different conversations that go on at the dinner tables between the public and the private path, okay? My family talked about mutual funds and tax increases versus the private path spoke about trust funds, and they still do, trust funds and tax avoidance. Matter of fact, my family told me I'd be thrown under the jail with the information I was learning, implementing, and sharing with them 25 plus years ago. The great thing is, once you understand the difference in this education, you will be able to keep more of your money and profits, that money and profit you work so hard for. You'll be able to reach your financial goals much faster. I mean, think about it. If someone's not taking a third of your earnings, wouldn't that allow you to get ahead faster? Of course it would. You'll be learning how to create generational wealth for your children and your grandchildren. The Bible tells us to leave an inheritance to our children's children. And we will show you how to do that. You'll have peace of mind that everything you work so hard for isn't just wiped away by one unfortunate incident. You won't lose sleep worrying about tax season or audits, and you only can designate the money that you make to the cause that you value, you and your family, what you are passionate about. Now, I want you to know, this information is not new, or it's not a novel idea. It's not something I made up or we're trying or anything like that. It's definitely not illegal. I don't roll like that, okay? This is proven and documented information over 100 plus years, and it's the information they do not want us to know. Let's talk about that for a minute. Why do you think they don't want us to know information? Whenever we're told something, we get an information or rules. Why do you think that is? You think maybe that's because someone wants us to know? They want us to know that information, use or follow those rules? And what do you think the reason is that we're not told information? Maybe that's because someone doesn't want us to know. They don't want us to use or follow those rules, huh? Now, when we're given a set of information, a set of rules, how is it usually enforced? Can we say, and probably a lot of things go through your mind, but can we say it boils down to people, consequences, whether you say it through an agency or a group or laws, whatever the case may be, it's either people that enforce that or the consequences that make us do something or not do something. And then how do we, and those enforcers, okay, learn this information and the rules? How do we actually get that? How do we know that it exists and things that they want us to know? We can agree maybe education, exactly, education. We're going to talk more about, we're going to get deep in that, education. Now let's talk about the 2 most powerful tools in the world. That's a contract and a proper jurisdiction. You marry the 2 of these together and you have what we call a bulletproof entity. Contracts are very powerful. Article 1 of Section 10 states of the U.S. Constitution actually states in part, no state shall pass any law impairing the obligation of contracts. So there's no state that can say anything that's going to stop whatever's in your contract. Very, very powerful. Let's talk about the judge shows. You know, you watch judge shows on TV. I can't think of any. I don't really watch TV like that. But regardless of the show, how crazy or entertaining it may be to you, at the end of the day, whatever judge it is, they always ask, is there a contract, don't they? And then they must go by that contract no matter how unreasonable it may appear. And here's why. We read the other court case, Hotchkiss versus Norfolk Petroleum. It says courts must enforce contracts as made, not make new ones for the parties. That's not their role to make new contracts, okay? No matter how unreasonable the terms may appear. Ladies and gentlemen, I'm telling you, contracts are very, very powerful, okay? However, you can find yourself in a very vulnerable situation if you're not in the proper jurisdiction. That's very key. So let's talk about the three jurisdictions. I don't know if you're aware. There's admiral, statutory, and common law. And these three jurisdictions, you have the option of participating in or operating under. I don't know if you know that we can choose where we operate. Now, the first admiral, that's military. Nobody really wants to operate in the military. Okay. Then we have statutory and common law, and that's English common law, not like common law marriages like we hear. Common law marriages, actually, because they vary from state to state, that tells you right there, those are statutory. Okay. Now, this English common law, this was around way before the states even existed. All the states except for Louisiana were operating under English common law. Louisiana actually operated under French law, Napoleonic law. So again, we can choose which law we operate under, and of course we don't want to operate under the military if we don't have to. But let's now look at the two that you can choose to operate under: common law or statutory law. So as you see, definitions of distinctions between common law. And basically what this is saying is common law is defined as a body of legal rules that actually have been made by judges as they are issuing their cases, their rulings for cases. So when judges actually make their rulings on cases throughout history, that is what's been put into common law and what's been used over and over, as opposed to statutory law, which are rules and laws that are made by legislature or any other official statutes. Okay. So let's look a little closer at the power of a contract in the proper jurisdiction. Yes, it's very, very powerful. Let's take a look at another court case, Crocker versus McClay. And this reads, a trust organization consisting of a U.S. constitutional right of contract cannot be abridged. If you have a trust put in place, and that is consisting of the U.S. constitutional right of contract, it cannot be abridged, cannot be stopped, cannot be changed, cannot be penetrated. The agreement, when executed, becomes federal organization and not under any of the laws passed by any of the several legislatures. So it doesn't matter who it is. They can't come and change the contract that you have in place. Let's look at Ashworth versus Hagen, where it reads, one of the main objectives of a trust contract is what? To obtain most of the advantage of corporations without the burdens and restrictions of the regulations that are imposed upon, again, by the statutory world. Okay? So you can have a trust contract, and nobody can come tell you any different. It can operate just as a corporation does, and without having to deal with all the burdens and the restrictions and regulations. The battle has already been won for you. As you see, I've shown you several court cases thus far. We're going to be looking at some more as we go along, because I want you to understand it's not your fight. The battle has been won. All you have to do is step in and make choices. So what we're looking at now is a contract. And let me just give you a little history with this. Of course, you've heard of the Internal Revenue Service. They were created in 1913. And if you remember, in 1903, our education system was created. And 10 years later, in 1913, remember, that's when Congress, they woke up about mistakenly giving too much power to those few gentlemen, those few families. Well, that's the same year, ironically enough, that the IRS was created in 1913. And then it only had two forms, two contracts. And here's one of them. Okay? One of them that was shared with you. Those on the private side, they learned about the 1041. This very simple, short tax form, it allows us to do almost everything I'm going to share with you in the rest of this session. Okay? Now, have you ever heard of the 1041? Probably not. Why do you think that is? Because perhaps you, like me, were on the public side. So let's take a look, a much closer look at the public side. So now we're going to look at a more recent Supreme Court case with clear distinction between two laws, two jurisdictions, and two types of trust. Okay, so we're coming up to our century now. And before I give the backdrop of this, I want to clarify two things. First, judge and justices. They're both enforcers, as we spoke about earlier. Judges are enforcers in the statutory world where you go before one judge. Okay, and then justices, they enforce this in the Supreme Court. And this is where you have more than one judge that sits on a bench. So there's less chance of rogue judges or of a rogue judge. The second point is Native Indians. They are exempt from paying taxes. I just want to make sure we're clear. They're exempt from paying taxes. However, they absolutely use trust, as you'll see in this article. So the backdrop is the Apache Indians. They have assets that are held in trust by the U.S. government, and the Indians felt that they were being mishandled. So they requested that the books be opened and have the corpus of the trust reviewed. The corpus of the trust is the contents of the trust. Okay. Now here's what the court said. You see that first arrow on the left? I'm going to read from there. It says, the opinion of the court by Justice Samuel Alito reasoned that the government acting as a trustee is unlike a trustee in a private trust created in common law. Unlike a trustee in a private trust created in common law, because the government is acting within statutory authority granted to it by Congress. So clearly, there's two distinct laws, common law and statutory law. And there's the private trust and the common law, and there's also the trust that the statutory group has created that the Apache Indians are actually under. Which, yeah, that's a terrible thing. But anyway, so basically, as the IRS tells us, that common law trusts don't exist, but you see that they do exist, and that the Apache Indians, they thought they had that. Now, if Justice Samuel Alito, he actually would have said to them, if common law trust didn't exist, don't you think he would have said, what are you talking about, Mr. Apache Indian? That there's no such thing as a common law trust, or it does no longer exist? Instead, he says a private contract, or excuse me, a private trust created in common law, okay, because the government is acting within statutory authority granted to it by Congress. Two different laws, two different trusts. The story doesn't end there, though. Justice Sonia Sotomayor, she didn't agree. It was actually her first year on the bench, and she was the only one who really stood up for the Apache Indians. Basically, she says that no, they're not structured properly, but our federal law, rule of evidence, the 501, says we are privileged to be informed of common law. So even though they're not structured the way they thought they were, we're privileged to know about this. And why don't we just do the right thing and give the Indians what they're supposed to have? One of the other justices did not even participate in decision making. Yeah, real crazy. So if the Apache Indians, they were actually structured properly, here's what the court would have said. Smith versus Morse says, the records of the trust are confidential, and their books and records are not subject to review or subpoena. Okay? So they wouldn't even have been able to open up those records if the trust was structured like the Rockefellers and the rest of the private families. Again, Apache Indians having them, the government and so forth, statutory world create their trust. They thought they were actually having the common law trust created. They sat there and let them do it, and they were beneficiaries, and they should have been a different position. Anyway, we will continue on. don't want us to know. Specifically, how to reduce your tax rate to 5% or less legally. Why? So you can have more control of your money instead of leaving control to others. Now, anyone who has a business or is looking to start a business, you'll actually start by looking at how you're going to structure your business. If you go to Google any of the state website or even DC's website, you'll find these options. You'll find that you can do as a corporation on the left-hand side, various types of corporations, like a limited liability corporation, that's an LLC for short, an S corporation, a C corporation. You also see you can go to sole proprietorship, even a partnership, whether it's a limited liability partnership, an LLP, or a general partnership. And DC, due to their site, they even have this business statutory trust. Again, business statutory, because they want you in their jurisdiction. Very key. So let's look at an example. In the public path, how would we actually operate? So we're starting with a single member LLC grossing $500,000 annually with $250,000 in expenses. That leaves $250,000 in profit. Normally, the member will take the $250,000 as income and expense it. Got to write down things and get it down to hopefully between $40,000 and maybe even $60,000 in taxes for that year. Okay. Or they can have the option to even pay 35% corporate tax rate. On that $250,000, that would be over $80,000. You see $87,500 in tax liability. Either choice, they will have to pay anywhere from $42,000 to $87,500 in taxes that year. Now, applying what Rockefeller said, okay, which includes a system of interrelated trust. Here's what we have: the business trust, which handles all the business. So this business trust will be created, and now it would actually become the majority member of the LLC. Now, the trust can do what we as individuals cannot do, and that is to pass on its profit to its beneficiary. In this case, its beneficiary is a family trust, and it can pass on up to 100% without any tax implications. So it passes on $250,000 to the family trust. The business trust is now zeroed out. There's no tax liability because it's $0. There's $0 to be taxed off of. Now we have the family trust, bringing in the $250,000. And this is where all the household expenses are paid: mortgage, rent, utilities, food, tuition, nutrition, cleaners, car expenses, insurances, etc., etc. For the sake of this example, we're going to say $150,000 for the expenses issues. That leaves $100,000 in taxable liability. Excuse me. Okay. So we moved that $100,000 to the last part of our series of interrelated trusts. We call it our PFF, the Private Family Foundation. Now, that one obligation for the Private Family Foundation, that is to disperse 5% of charitable 5% of its donation to a charitable organization. Okay. So what does that look like? It receives $100,000 from the family trust. That zeroes out the family trust. Again, zero tax liability, so we pay no tax between the business trust and the family trust. Okay? We have $5,000, 5% of the $100,000 that we need to be able to expense. So we need to give that either to our church, to our alma mater, to the library, a hospital that we're fond of. That leaves us $95,000 left to what? Invest in anything legal and lawful. Now let's take a look at the foundations real quick, because I'm sure you've heard of foundations, just like I had public foundations that I was talking about versus private foundations, private family foundations. They're both nonprofit, 501c3, or they can be, let's say. And both can receive charitable gifts, which are 100% tax deductible from the giver or the donor. Public foundations are like the American Lung or American Heart Association, Sickle Cell Anemia Association, maybe even the Boys and Girls Club. You've heard of these, okay? They're single causes, single charters, why they exist and what they operate under. And regardless of what their charter is, each one public foundation has to give 80%. 80% of whatever comes in has to go out that tax year. It's called an 80% expenditure rule. Yes. But the private family foundation, on the other hand, similar to the Bill and Melinda Gates, Oprah Winfrey Foundation, and some of the big boys, the Rockefeller and Carnegie Foundation, they're all private family foundations, private foundations. Here we can have multiple causes anytime. Whatever we want to donate or give to support, we can do it without having to go back and ask for a charter, pay any more money. And we have a 5% expenditure, which is great, 5% expenditure rule. So as you saw in this example. So let's do a quick review between the public and the private, okay? We went from paying $40,000 and upwards of $80,000, almost $90,000 in taxes to Uncle Sam, didn't we? Yes. To paying $5,000 to charitable organizations, one of your choice. So it didn't even go to Uncle Sam, because 5% had to go to an organization of your choice. The great thing is, there's $95,000 tucked away in an entity, the Private Family Foundation, that can invest in anything that's legal and lawful. Whether it's a profit business, for-profit, or non-profit, it doesn't matter. They can be invested in a for-profit business and grow money tax-free, legally wrong. Very, very powerful. This is why we have some major corporations that they're not paying taxes. And they're legally not paying taxes, like Amazon. They make billions of dollars, and you'll find their articles of the corporation, they're owned by properly structured trust contracts. Yes. And we may not have as many zeros as Amazon, but that doesn't stop us from being able to operate in the same space. A powerful space to operate in. The Uniform Trust Code, also known as UTC. This is a federal statute from Congress, and it was put together to guide the states on how to deal with trust. Now, sections 106 and 107, they deal with common law trust, again, what the IRS says don't exist, okay? But let's sum that up with the Uniform Trust Code, what they actually say. So, basically, the Uniform Trust Code, it does not try to incorporate detailed rules, okay, for every conceivable kind of trust, because there's so many out there. It does not contain statutory rules that are already governing trust in many jurisdictions, and they're working just fine. It does not displace any of the actual trust or acts that are out there already. It's just a basic set of default rules that are fairly consistent and they clearly govern voluntary trust. And that last line is very key. That's why it's highlighted and underlined, okay? It's a default statute for the most part, because the terms of the trust instrument will always govern, even if it's inconsistent with what the statutory rule says. So at the end of the day, even though there's a guide with the Uniform Trust Code for the states to use, the trust contract, whatever is in there, supersedes anything that's in the UTC. Very, very key. Very, very key. So that's how powerful the trust contract is. What we're going to do right now is wrap up with the most cited court case that it has everything to do with all that we've been talking about here, and that is Hale versus Hinkle. And Hale versus Hinkle, this is all about your right to privately contract. This is the most cited case in American history, ladies and gentlemen. Okay? Okay? And the Supreme Court, that's the highest court. That's what the president has to go to. They bypass all these other courts. They go straight to the Supreme Court, the president of the United States. The great thing is we have the option to operate in the same space. The way we determine how we operate is to go straight to the Supreme Court, is we determine it up front. So we're going to operate in the Supreme Court space, common law, English common law, or in some other jurisdiction. Okay? Now, this case has been cited over 1,600 times since 1906. I want you to understand what that really means. Because you, like me, that didn't really make a whole lot of significance to me. Okay? But a Supreme Court, if you see the more times that the case is held up as law, the more it becomes cast and granted. And has anything ever overturned Hale versus Hinkle? Never. There's not been one issue, one case that has ever overruled Hale versus Hinkle. However, it's been cited many, many times. So it is what we call the law of the land. And let's see what this actually states. Basically, in a nutshell, I'm not going to read all this again for the sake of time. But you go look it up on your own. Hale versus Hinkle. You can go Google it, whatever the case may be. It's talked about us as an individual. We may stand upon our own constitutional rights as a citizen. We're entitled to carry on our private business in our own way. We have the power to contract and is unlimited. We can contract as many times as we want, however much we want. We owe no duty to the state or to the neighbors, our neighbors, to divulge our business and what's in our contract. We don't have to open our doors to any investigation at all. Basically, as long as, and I'm skipping over to the third column, it says, the highlight, as long as we owe nothing, as long as we understand we owe nothing to the public, so long as we do not trespass upon the rights of others. Very, very key. So you see, we owe nothing to the state, neighbors, or the public, as long as it doesn't infringe on their rights. So Nelson Rockefeller, the Rockefeller family, Mitt Romney, Donald Trump, and yours truly, honestly, to name a few, we exercise our right to private contract. We know the battle has already been won. We are very clear on that. As I said earlier, it's been won. I spent time going through all this, including all these court cases and IRS.gov, to show you that it's not your fight, ladies and